Hi, and welcome back to Law and More. Let's talk about the difference between letters of administration and the grant of probate. When a person dies, they can either die testate or intestate. If they die testate, it means that there was a will. If they die intestate, there is no will. If there is a will, the executor has to apply for the grant of probate. With no will, the applicant has to seek letters of administration. In terms of letters of administration, applicants are ranked according to survivorship, which means that there's a tier of preference in terms of applicants. The top tier would be the surviving spouse, which includes cohabitants or common law spouses. Then you have children, of course, adult children, because minor children cannot apply for letters of administration. Then you have parents, then siblings, then you have grandparents, then nieces and nephews, aunts and uncles, cousins. So it goes in a very specific hierarchy of preference. The documents that you need for a grant of probate are the original will, the death certificate, the IDs of the executor and beneficiaries, an affidavit from the executor, and an affidavit from at least one of the witnesses in terms of the will being duly executed. The documents that you need for letters of administration are the death certificate, the ID of the applicant, a document which proves the relationship between the deceased and the applicant. This includes marriage certificate, birth certificate, if in the cases of adopted children, the adoption documents. And if there's a situation where there are several next of kin on the same level, for instance, if there are several surviving children, there would need to be an agreement amongst the surviving children that sibling A is the one applying for the letters of administration, and they would need to indicate that via a renunciation. Now, some persons think that there are certain assets of a deceased that you may not necessarily need a grant or letters of administration for. For instance, there could be a situation where you have a brother, he passed away, he left his car, you're using his car, but you're now ready to dispose of that asset. You want to sell it, and therefore you have to transfer it. When you go down to licensing, they will ask you for either the grant or the letters of administration. And if you cannot produce either, then you cannot transfer the car. Another common scenario is in the instance of a life insurance payout. There are certain circumstances where there is no named beneficiary on a life insurance policy, and the beneficiary is the estate. So in order for that policy to be paid out, either a grant of probate or letters of administration must be produced. A death of a family member is already a difficult time. It can be very stressful, particularly when that family member is a close family member, an immediate family member. So why not make it easy on your loved ones? Make the will now. And thanks for following me on all of my social media pages, TikTok, Instagram, Facebook, YouTube, at Law and More TT. I really appreciate the support. So until the next time, bye.